Another, more modern example of a mechanical unilateral mistake can be found in Chu King Kong and Digiland Mall. In this case, Mr. Chu found that Digiland Mall were selling printers online for far less than the usual price. The usual price of these printers was around $4,000. However, they were being sold on Digiland Mall's website for $66. Chu then ordered a large number of these printers. The next morning, Digiland Mall discovered the mistake and altered the price on their website and sought to cancel the contract with Mr. Chu. Chu insisted on getting the printers he had ordered at the price of $66. The court held that there had been a mechanical mistake on the part of Digiland Mall. This means that they simply entered the wrong numbers into their computer system when they set up the website for selling these printers. Since Chu knew of this mistake, or must have known of this mistake, the contract was void for unilateral mistake. Again, this is an example of a mechanical error as opposed to a business error. In other words, if Digiland Mall had just gotten the business side of things wrong and had mispriced their printers, the contract would have stood. But since there was a mechanical error, the contract was held to be void. Very often, unilateral mistakes involve mistakes as to identity. In order to set aside a contract due to mistake as to identity, 3 requirements need to be fulfilled. First, the person invoking unilateral mistake must have thought they were dealing with another party. A good case to illustrate this is Kings Norton and Edridge Merritt. In this case, a crook had used a letterhead of a fictitious company, Hallam, to order a number of goods. Kings Norton then sent out the goods on credit, believing that they would be paid. In fact, the crook sold the goods on to another party, and Kings Norton were never paid. When Kings Norton uncovered what had happened, they sued Edridge, who was a third party who had bought the goods from the crook. Kings Norton argued that they had made a unilateral mistake as to the identity of the person they were dealing with. They felt that they were dealing with Hallam, and of course they were not dealing with Hallam at all. They were dealing with a crook. However, because this company, Hallam, that the crook had made up, because this was a fictitious company, the court held that Kings Norton was not in fact mistaken as to the identity. They could have only been mistaken as to the identity of the other party if there was another party, another company called Hallam. But of course, there was no such other company. Hence, the contract was not set aside for unilateral mistake, and Kings Norton was not able to recover damages from Edridge. The second requirement for setting aside a contract due to mistake as to identity is that the other party knew of the mistake. Now, usually this is a given. So, for instance, in Kings Norton, the crook knew, of course, that the other party was mistaken about his identity. So, this requirement is rarely an issue. However, in some scenarios, it may be an issue, such as in Bolton and Jones. Jones was someone who had dealings with another person called Brocklehurst, and Brocklehurst owned a company. Brocklehurst owed Jones some money. Jones then ordered some goods from Brocklehurst's company. What Jones did not know is that on the very morning he made that order, Brocklehurst had sold his company to someone called Bolton. Bolton then processed the order and delivered the goods to Jones. But Jones refused to pay. After all, Jones thought that he was dealing with Brocklehurst, and since Brocklehurst still owed him money, he wasn't going to pay. So Bolton sued Jones. The court held that Jones never intended to contract with Bolton, and therefore there was no contract. Third, to successfully argue for mistake as to identity, one must also show that the identity was of crucial importance. In Phillips and Brooks, a crook went to a jeweler's and bought a ring. The crook said that his name was Sir George Bollow, a well-known person in that locality. Believing that he was dealing with the George Bollow, the jeweler sold the ring to the crook in exchange for a check. Of course, the check bounced, and the crook sold the ring on to someone else. The jeweler then sued that third party to get his ring back. It was argued that the jeweler had made a unilateral mistake as to the identity of the person they were dealing with. However, the court held that although there was a mistake in the sense that the jeweler thought he was dealing with someone else, and although the crook obviously knew of this mistake, the identity of that someone else was not of crucial importance. In other words, the jeweler was not so much concerned with whether he was dealing with George Bollow. What he was really concerned with was that he was dealing with a person of means. That was the important thing. The test here is to ask whether the jeweler would have sold the ring only to George Bollow to the exclusion of anyone else. And of course the answer is no. In fact, the jeweler would have sold the ring to anyone he thought was wealthy enough to be good for their payment. As a result, the jeweler was not able to recover the ring from the innocent third party. A very similar scenario played out in Lewis and Avery, which was a case about the sale of a car. The owner of the car sold his car to a crook whom he believed to be a famous actor, and in fact, the crook was passing himself off as being this actor. It turned out, of course, that the crook took the car, sold it on to someone else, and then the original owner sought to recover the car. Again, the court held that this was not possible because, in fact, the original owner had dealt with the person in front of him. Now, whether he thought this was a famous actor or not was not of crucial importance. What was of crucial importance to the original owner was that he thought that the person in front of him was a person of means. And that is merely a characteristic of a person. It is not the identity of that person. So the outcome was the same as in Phillips and Brooks. However, we need to contrast these cases against other cases, such as Cundy and Lindsay. In that case, a crook passed himself off as a company called Blank Iron. Now, in contrast to King's Norton Metal, this company, Blank Iron, actually existed. Therefore, Lindsay, who were the manufacturers of handkerchiefs, went ahead and sent out the order on credit. Now, of course, just as in King's Norton Metal, they were never paid, and the crooks sold the handkerchiefs on to someone else, an innocent third party. When the innocent third party, Cundy, refused to return the goods, the matter went to court. After conflicting judgments in the Divisional Court and in the Court of Appeal, the House of Lords held that Lindsay, the manufacturers of the handkerchiefs, in fact only intended to deal with Blank Iron to the exclusion of anyone else. Hence, in this case, the identity was of crucial importance. Title to the goods never passed to the crook, and therefore it never passed to Cundy either. Cundy was forced to return the goods. Ingram and Little, two sisters, sold their car to a crook. The crook passed himself off as a Mr. Hutchison and gave an address. When Mr. Hutchison tried to pay by check, the sisters were very wary. One of the sisters went down to the post office to check the phone book and check the records as to whether there was a Mr. Hutchison at this address. When she found that there was, they went ahead with the transaction. In this case, the court held that the identity was of crucial importance and that the contract was void for mistake. This is a very controversial decision because it flies in the face of both Phillips and Brooks and Lewis and Avery. But look at a few more unilateral mistake cases. In Webster and Cecil, similar to Hartog and Colin Shields, a mistake was made as to the price of a property. An offer of £2,000 was rejected, and then because of the mistake, the seller suddenly quoted £1,250, which is of course less than £2,000. So clearly a mistake was made, and the buyer must have known about this. This contract was held to be void. Hardman and Booth, a son bought some goods on credit from a company pretending to be a representative of his father's company. In fact, he had no authority to act on behalf of his father's company. The question arose whether there was a contract between his father's company and the company that had delivered the goods. The court held that there was no such contract because, in fact, the company that had delivered the goods only contracted with the son. Lake and Simons, a fraudster, obtained 2 necklaces from a jeweler pretending to be the wife of a well-known businessman. Here, the court held that, in fact, the jeweler had only intended to contract with the wife respective the businessman. Hence, there was no contract. In Shogun Finance versus Hudson, a crook had obtained a car, which he then sold on to an innocent third party called Hudson. Now, the car was obtained from a dealership, but the financing agreement, which the crook had entered into, for which he had never made any payments, was with another company, Shogun Finance. Since there had never been any face-to-face meetings between Shogun and the crook, the court followed the ratio in Cundy and Lindsay. There was no contract because Shogun Finance only intended to deal with the person they believed to be Mr. Patel, but who in fact was the crook. Lastly, there's also a mistake which we can call documents mistakenly signed. This happens when people sign something believing it to be something different from what it is. Of course, we could regard this as a unilateral mistake, but generally the courts have treated this as a separate category. We can call this the doctrine of non est factum. Non est factum basically means it is not my deed. A claim under the doctrine of non est factum means that you are pleading that although something was signed by someone, it was signed by mistake, the mistake was not negligent, and the contract should be set aside. Saunders and Anglia Building Society, an old lady, Mrs. Galley, wanted to pass her property to her nephew. Her nephew brought in a friend who was going to help with the paperwork. Unbeknownst to Mrs. Galley as well as the nephew, this friend was basically a crook who made Mrs. Galley sign a form which gave the nephew the right to mortgage the property. The friend defaulted on the mortgage and the bank claimed the property. By the time this matter came to court, Mrs. Galley had died, so she was represented executor Saunders. The House of Lords held that this was not a case of non est factum. The contract stood. Mrs. Galley should not have signed something without knowing what it was. The court further held that in order to plead non est factum, whatever the person signs must be radically different or fundamentally different from what they think they're signing. In other words, Mrs. Galley signed a piece of paper for passing title of her property. And in fact, even though it was passed to someone else, it was still a piece of paper to pass title. So it was not fundamentally or very substantially different from what she thought she was signing. And hence, the claim of non est factum did not succeed. Saunders was based on another case called Foster Mackinnon that preceded it. In Foster Mackinnon, there was an old man who signed a form that he believed to be a guarantee, but in fact it was a bill of exchange. It was held that the old man was not liable for the bill of exchange. That is because what he signed was fundamentally different from what he thought he was signing. Secondly, he was not negligent in signing this document. Thus we can say that in order to plead non est factum, there's a two-stage test. First, is the document that is being signed fundamentally different from what the person signing it thinks it is? Second, was the person signing it negligent in signing it? Regarding the first part of this test, the fact that there must be something fundamentally different between what the person thinks they're signing and what they're actually signing. Initially, it was not clear whether that went to the contents of what they were signing, the character of the document as a whole. In Howitson and Webb, this distinction was made. Thus, where the mistake was merely as to the contents of the document, the plea of non est factum was not available. However, Saunders suggests that this distinction is no longer applicable. All we need to ask is whether there's a fundamental difference between what is being signed and what the person thought they were signing.